Julie, I just got a copy. Matt just handed me of the amended verdict slip for count 2.
Amended?
So let me
when
go
was
through
it
that.
amended?
The amended has been released. So if you find the defendant not guilty of the offense charged or any of the lesser included offense, stop and sign the verdict slip. Then it goes to guilty of offenses charged. Manslaughter while operating under the influence. Check one or both of the followings. What she's added are these notes in parentheses, and I'm trying to. I can't figure out how to scroll on this.
Yeah, I know you're reviewing it right now.
Vinny,
when did she amend it? If you know, what's Matt saying? Did this just happen this morning?
No, yesterday it was amended. It just wasn't released. There were copies given to the jurors, but not made public. So we have a copy of it right now.
I see.
Can I bring Matt in here to help us scroll?
Sure.
Help us scroll.
Let's welcome him in. Hi there, Matt Johnson.
Matt's going to be my scroll. Okay. Here we go. I'm going to read it from the top. So it goes number 1, not guilty of the offense charged or any lesser included offense. That's the same. Then the addition is in parentheses. If you find the defendant not guilty of the offense charged or any lesser included offense, stop and sign the verdict slip. Then it goes to number 2, guilty of the offenses charged, manslaughter while operating a motor vehicle under the influence of liquor. Then it gives you the 2 choices. Check one or both of the following. That remains the same, manslaughter or .08. Then there's a new paren. If you find the defendant guilty of manslaughter while operating a motor vehicle under the influence of liquor, stop and sign the verdict slip.
This is so
if you find her not guilty of if you find her not guilty of manslaughter,
yes, we'll see if we can get this in our system to show everybody at home.
Yeah, absolutely.
Because you're right, Vinny, as you're saying,
absolutely.
It's pretty much telling them stop. If you've arrived at a decision, stop. You don't need to keep going, and it pretty much forces them to go top down, as Her Honor had instructed. Wow, what a difference this makes, huh, Vinny?
Much better, much better. And you know, part of the reason a lot of people were saying, why don't you put a not guilty box next to each lesser included? The problem is the law in Massachusetts doesn't permit that. They don't permit partial verdicts for lesser included offenses. So if you put the box in there and they actually check a not guilty verdict, then jeopardy attaches.
Bingo.
And if they get hung on a lower lesser included offense, the person can't be retried for the top offenses. That's the way Massachusetts wants it. That's the law. The judge is following the law. That's why she didn't put those not guilty boxes as a choice there. But the jury clearly needed more guidance because we had similar problem, slightly different, but a similar problem with the first jury. So this is much clearer. It's in bold. I always read the bold, right? You're not going to pass by the bold. It's not a footnote. It's not an oral instruction, a verbal instruction. It is written down on the slip so they can all read it together and understand how you do it step by step. So let's hope and pray, because all we want is the jury to understand how they are to communicate whatever their agreements are inside that jury room. The first jury didn't know how to do it. They did not understand it. And if the second jury is having problems as well, it's not a problem with the citizens, the 12 in the box, now 24 in the box. It's a problem with Massachusetts system of justice and the way they communicate with the jurors. So they need to fix that. I think hopefully the judge fixed it on this verdict form. Let's hope, because that's the bottom line. You don't want a jury to agree to something and then not know how to communicate it to the judge and to the court and to the public.
You're absolutely right, Vinny. And as I'm reviewing this form, and we're working right now to get it ingested into our system so that we can show it to everyone, and you'll see what Vinny and I are talking about here. It's almost like the way Judge Beverly Cannone was saying it to the jury when they were in the box yesterday afternoon, and she was saying, you know, you start at the top. If you find not guilty, here, just stop. The inquiry ends right there. But if you don't, keep on going. And then it's almost like her verbiage that she used yesterday in the courtroom has been now attached to this in bold, as you noted, Vinny, to make it so simple so that they look at each number one by one and understand what's at stake here. So this is a big deal that this was added yesterday afternoon, and I think perhaps a little known fact as well, because since this wasn't released until this morning, moments ago, we weren't able to pour through it. Vinny, tell me, seeing this now, noting that it's Wednesday, you made the point earlier about how tomorrow's Thursday, tomorrow's the Juneteenth holiday. We don't know if court would even be in session on Friday after that. Do you think we're likely to see either a verdict or the jury come to no decision today in the declaration of a mistrial today, this Wednesday?
Yeah, my gut tells me that today's the day that the jury will speak. And when I say the jury will speak, they'll let us know where they are. You know, we're deadlocked, we've reached a verdict, and hopefully if they've reached a verdict on one or more counts, they communicate that. And they don't leave any gray area here. Here's where we are on charge 1, here's where we are on charge 2, here's where we are on charge 3. That is so crucial, so important in the way all this has played out, especially after the first trial. I think the other thing that the Commonwealth of Massachusetts should do on these verdict forms, if it's a lesser included, instead of just listing them as numbers, because they're all listed like 1, 2, 3, 4, 5, and if you just look at it, they all kind of look the same. If it's a lesser included, I've seen this on other verdict slips in other states, indent it. And maybe don't call it number 3, call it 2A, 2B, 2C. However you want to make it so it's clear that it's a lesser included rather than a completely separate charge. Because if you just list them 1, 2, 3, 4, 5, they all look like they're the same, but they're not the same. They're not the same. There's a huge difference between the top charge and the lesser included. Big difference in how it impacts what could happen if they're deadlocked. And I think that clarity would help. But I think this judge's instructions are perhaps something she may use every time in the future when she's got lesser included charges in a case.
I sure hope so, Vinny. I'm with you. Let's go through, while we have a moment, these lesser included offenses for anybody wondering. So we've got the big umbrella of manslaughter while operating a motor vehicle under the influence of alcohol. And underneath that, the possible lesser included offenses, if they don't find her guilty of that charge, could be involuntary manslaughter. That's an option. Motor vehicle homicide, which is a felony, OUI, including negligence, another potential option. Or the operating under the influence of alcohol offense, the lowest of them, that number 5 that was used as the example yesterday. And Vinny, speaking of course, everybody wants to read the tea leaves with that question when the jury said, what if we were to say, for example, we find her guilty of count 2, subsection 5. What does that mean of the overall charge? And everybody right away said, oh, does that mean they want guilty of operating under the influence to be the only charge they're finding? How important it is, do you think, that we take them for their word that that was an example?
Yeah, well, here's the thing. I don't know if they realize the impact that that has on everyone. Whether it's John O'Keefe's family, Karen Reed, her family, the lawyers, the public. You start sending out saying not guilty, and then you start giving examples. I would think you would know, but maybe they don't, how people are going to react to that. There's going to be a visceral reaction and expectation. People aren't going to say that that's the expectation, but why would you use an example if it wasn't where you actually were? Because then, could you imagine, you send out a message saying, if we're not guilty on 2 charges and we're hung jury or hung on a 3rd charge, and then you come back and that's not indicative of the final verdict, people are going to be like, well, what just happened? Why would you send that out? It's almost cruel to the parties involved, both sides, that you would send that out. I mean, the gut punch that the O'Keefe family must have felt when that note was sent out, and then the level of potential optimism that the defense felt and Karen Reed felt at that moment. It's almost cruel to both sides. I'm not blaming the jury. No one instructs them on how to do anything, specifically in the way they communicate back and forth. But that's the impact of it, right? So I'm taking it that they would understand that. And if they understood that, I think it would sort of mirror or track where they are in their deliberations. If not, then it's tough. It's really tough on the parties involved in this case if it comes out very different from what they've indicated so far.